So religious refusals is the jargon that we use to not be just confused with the jargon the other side uses, which is conscience clauses or conscience exceptions. I mean, there are legitimate conscience exceptions in all kinds of settings where a person, an individual person, can make a choice about whether he or she chooses to participate in certain kind of health care. But an institution like a hospital or a doctor's office, if it puts itself out as serving the community and providing high-quality health care, it has to provide high-quality health care to everyone. And so a hospital or a doctor's office or a pharmacy is not allowed, under most of our laws, and these are things that we're still fighting over, is not allowed to say, I don't approve of either your sexual orientation or your family formation choice or your reproductive choice, and then deny you service. Although this is what we're fighting about over and over again, it's certainly been a big issue in terms of emergency contraception and pharmacies choosing to refuse, or pharmacists choosing to refuse emergency rooms and so on. In California, there is, I was going to say was, or it still is, of course, a lesbian and her partner, Lupita Benitez, and she wanted to have a child and needed fertility treatments to get pregnant, and was referred by her insurer to a particular medical practice. So there was some reason that she felt that she needed to go to this particular provider, and went through all the initial steps of the first round of screening for those procedures. And then as she was about to receive the treatments that she was seeking, the doctor said, I don't want to provide them. I don't approve of your choice. You're a lesbian, and I don't think I should assist you in having a child. There are many legal steps in between, and they're outlined here if you want to read them on the back of the page, but we represented her and we sued. Now, the helpful thing in this particular case is that there's a very good and very clear anti-discrimination law in California. It's the UNRUH, Civil Rights Act. I don't know exactly how you say it, but it includes, of course, protections against discrimination on the basis of sexual orientation. And as you probably know, not all states have such laws. Only approximately 20 plus the District of Columbia have statewide anti-discrimination laws. But under that law, we represented Benitez. We won at various levels. The other side kept appealing. And then the California Supreme Court said in a victory last year that under the anti-discrimination statute, doctors' offices cannot pick and choose who they wish to serve, or they cannot discriminate based on their own religious beliefs. If they want to have their religious beliefs, then the doctor's office has to figure out a way to serve everybody, or they have to get out of that business. You can't put yourself out as providing a complete service to the community under certain medical guidelines and then say, oh, but I won't do that. And so we won that case, and Lupita Benitez, I would like to tell you, has long since moved on to other healthcare providers and has a lovely family. So that's the good news. But it's also good news that in California it is now clear that claiming your own religion prohibits you from providing a medical service is not acceptable under their state anti-discrimination statutes. We had other cases that are similar, and I just want to make it clear that these same issues affect gay men who want to be fathers, just as Terry was describing. We are representing a gay man in Florida who's been denied insemination services under a surrogacy agreement that he had with a woman, and they just simply refused to do it, saying, actually they claimed that it had to do with prohibitions on semen coming from men who have sex with men, which is what you're talking about before, but it doesn't apply in this case because it was two known parties who had made an agreement. It wasn't, this is a law that applies to the sort of sperm banks, but doesn't apply to individual agreements between parties. So we're representing him. And in another case that we won without ever finally going to court, there was a gay man who was refused Viagra by his primary care doctor, who thought that he disapproved of his sex life and didn't want to give him the same medical care that anybody else with erectile dysfunction should be entitled to get. And so those are some examples of prejudice leading to the denial of care. Another area that Terry made reference to that we do an awful lot of work on at Neighbor Legal is about family formation through adoption. I didn't come prepared to cite cases, and I think I would just leave it if I tried to. but there are many, many states now where there are good laws and good case laws allowing either lesbian and gay individuals to adopt, and also once lesbian and gay families are formed for the second parent in that family to adopt as a second parent. But there are some states where that's not the case, or the state law isn't good, or the case law isn't good. And there are cases also where parenting is challenged once the couple breaks up, when there's a divorce or a separation. And then we do talk about parents behaving badly, because then we have parents who use anti-gay arguments to try to undo or revoke the parenting relationship of the partner with whom they are breaking up. And unfortunately, but I'm here to tell you that same-sex couples can behave just as badly as opposite or different sex couples in the